Supreme Court, in the matter of GASTRADE International versus Commissioner of Customs KANDLA, allowed the appeals by setting aside the impugned common judgment and order dated 20th January 2022, passed in revenue tax appeals, and gave benefit of doubt to appellants because of the inconclusive evidence rather than directing for a fresh testing and seeking fresh expert opinion as a one time measure. Certain ancillary directions were also given by the court in this matter. Court said that we are of the view that non-examination of any product, article, goods on all the parameters laid down by the custom authorities will always lead to uncertainty and doubt, which are required to be removed when dealing with confiscatory proceedings. The genesis of the prolonged litigation lies in the non availability of adequate facilities for testing all the parameters provided under Bureau of Indian Standards specifications. Such a dispute could have been avoided had the testing facilities for all parameters been available. Since the authorities themselves had laid down the specific parameters for classification of goods, as in present case by referring to classification under IS 1460/2005, it is incumbent upon the authorities to ensure that necessary facilities are made available for testing of any disputed article on all these parameters, as otherwise laying down such parameters would be meaningless. Hence, to avoid these difficulties, doubts, and uncertainties in future, respondents were directed to ensure that proper facilities are made available in appropriate laboratories for undertaking tests for all these parameters, or at least for those parameters which authorities consider are of essential character to satisfy most akin test, without which article in issue cannot be properly classified. Accordingly, Supreme Court directed respondents to take necessary steps in this regard within 6 months for proper testing in all the parameters in future. The issue involved in this batch of appeals was whether the imported goods is to be treated as base oil as claimed by appellants or high speed diesel as determined by the customs authorities, which is contested by the appellants. If the product is treated as HSD, it would be a prohibited item that could not have been imported by private entity other than a state trading enterprise, in which event it would be liable to be confiscated and penalty be imposed on the appellant importers. Educating authority as well as High Court, without there being any such categorical opinion in the report by expert, nevertheless went on to conclude that samples were indeed of HSD by applying the test of preponderance of probability, which Supreme Court said we feel is problematic. In this case, analysis and conclusions arrived at by High Court were problematic for the following reasons. There was no expert opinion at all. The samples which were tested were indeed of HSD. The opinion, as contained in the test results, was merely mentioning about conformity of samples with certain specifications of IS 1460/2005 and not about conformity with all the specifications. Once the rulemaking authority had clearly delineated the requisite parameters for ascertaining the nature of goods or substance, compliance or conformity with the stated parameters would be the requirement. There are 21 parameters laid down under IS 1460/2005, and none of the tests have shown compliance with all these parameters. The last and third test had reported compliance with 14 parameters, though, as discussed, in respect of two of 14 parameters, namely flashpoint and distillation range, the same were not in conformity. Thus, it cannot be said there is substantial compliance with the parameters of IS 1460/2005. Flashpoint, though, may not be the most important parameter, yet its importance in determining the nature of automotive oil cannot be ignored. Flashpoint being a very important criteria to classify petroleum products, non-compliance of the samples of this parameter would make classification doubtful. Evasive answers and non-clarification of certain aspects of flashpoint of samples by expert Dr. Gobind Singh certainly cast a serious doubt on samples being identified as that of HSD. Expert himself has not said samples are of HSD except for stating that samples conform to certain specifications of IS 1460/2005. In view of ambiguity and lack of clarity in expert opinion, laboratory test results, it would be unsafe to draw the inference that department had been able to prove their case even by applying test of preponderance of probability merely because samples conform to certain parameters. If department with all the resources at their command and access to various laboratory facilities could not get samples tested in respect of all 21 parameters, expecting the assessees or appellants to get samples tested to show that these do not confirm specifications and are not HSD does not appear to be reasonable. Thus, shifting of onus to assessees to prove otherwise appears to be unreasonable and meaningless. The burden was not on the assessees to demonstrate that non-conformity with the remaining 8 parameters would vitiate conclusion that samples were of HSD. Aforesaid difficulties, in the opinion of Supreme Court, can be overcome if the test of most akin is applied as contemplated under Rule 4 of the General Rules for Interpretation. The real test for classification, according to Supreme Court, would be as to whether any goods or substance in question is most akin or bears the closest resemblance to any similarity any of the specified goods mentioned under headings and relative section or chapter notes under the Tariff Act, and not by applying the test of preponderance or probability.